This is the next lecture after the previous case, which was contract support services, that I gave a brief talk on. In fact, what I'm going to do in this lecture is cover a few cases. If you turn to paragraph 3.21 of your textbook, you will see that the contract support services case, as well as the some of the other cases that I have asked you to read, and I'm just quickly paging through here under this particular section. Hindry versus Nedcor Bank Limited, contract support services, which you've already dealt with. Mpande Food Liner Close Corporation, and then we've got SARS versus Hawker Air Services, which we previously looked at, and then of course Deacon and Controller of Customs and Excise. All of these appear under the chapter subsection procedurally fair administrative action, and many of these cases were decided prior to the Promotion of Administrative Justice Act in fact taking effect. And with the Promotion of Administrative Justice Act taking effect, which is really an extension of Section 33 of the Bill of Rights contained in the Constitution, Section 3, subsection 1 of PAJA, Promotion of Administrative Justice Act, is obviously abbreviated as PAJA, provides that administrative action which materially and adversely affects the rights or legitimate expectations of any person must be procedurally fair. So firstly, administrative action, and we must determine what administrative action is, but that's not for this lecture, which materially and adversely affects the rights or legitimate expectations of any person must be procedurally fair. And we're dealing with procedural fairness. And I quickly just want to take you back to what has been said before in terms of the case law. I remember in contract support services, it was held that not all administrative acts require the application of the audi alteram partem rule, which means the taxpayer must be heard in this case, and that no notice or prying hearing is required where this would render the proposed act nugatory. In other words, it would defeat the objects of SARS trying to act quickly and smartly, as in the instant case where notice or hearing would have given the taxpayer the opportunity of spiriting away the funds to which SARS was laying claim to. Well, in the decision in Hindry versus Nedcor Bank, this concerned a challenge to the constitutionality of Section 99 of the Income Tax Act, which empowers the Commissioner to appoint any person as the agent of a taxpayer and obliges that person to pay to SARS any tax due by the taxpayer out of the monies held by that person on behalf of the taxpayer. The taxpayer argued that Section 99 violated his constitutional rights to administrative justice, privacy, and the rights of access to the courts. The court held that the section did not violate the Constitution for the following reasons. The taxpayer had ample opportunity for a later judicial determination of his legal rights. The section was an example of summary proceedings to secure prompt performance of pecuniary obligations to the government. The purpose of the section was to avoid assets of the taxpayer being placed beyond the grasp of SARS. The section was no more than a form of garnishment and was a legitimate limitation of the taxpayer's rights in terms of Section 36 of the Constitution, and was necessary and reasonable in an open and democratic society. The claim in question had been the subject of considerable correspondence between the taxpayer and SARS, in which the latter had explained how the amount had been arrived at. There could thus be no complaint of unfairness or failure to give reasons, or that the principle of audi alteram partem had not been applied, even though the applicant was given the opportunity of being heard only after the decision had been taken. So again, that's just a deviation from the audi alteram partem rule in terms of giving the taxpayer an opportunity up front. But you'll note that in most of what we do, which is to really deal with the preparatory investigations that SARS embarks upon before arriving at a revised assessment, we would be doing exactly what was set out in the Hindry case, and that is by exchanging a lot of correspondence with SARS to elicit from them what it is that they are currently investigating, why they're investigating. Are we obliged to give them the information which they're requesting? And if we are obliged to do so, we're doing so under compulsion, and there will be certain constitutional rights which we can rely on, the primary one being that evidence, direct and any derivative evidence from that, can never be used against our taxpayer client in any future criminal prosecutions, and we would make sure that that evidence is given by way of correspondence through a tax attorney as opposed to an accountant, simply because the tax attorney with the legal privilege rule can give that information on behalf of the taxpayer. If the accountant gave it, of course it wouldn't be the taxpayer giving the information, it would be from a third party and would therefore be admissible in any criminal prosecution. So one's got to be careful of that. Then in the decision of Mpande Foodliner, there were certain notices set aside issued under the VAT Act on the basis that they violated the Audi Altrum Partum rule. Now, of course, those of us who act for taxpayers will like the Mpande Foodliner judgment because the judge was quite liberal in his striking out what SARS had done wrong. But in legal circles, this particular judgment has not been highly rated, in the sense that it has been overturned or it has not been followed in subsequent judgments. And the judge in this particular matter, the rumor has it that he was particularly peeved off with the commissioner and with SARS because he had an altercation with them, either himself or possibly on behalf of a client, prior to him being appointed as a judge, and people believe that that may have influenced his particular approach to SARS in this matter. Not much reliance can be placed on that, but of course the important thing is that it's a judgment that has not been that closely followed in subsequent cases. Then of course the final one I wanted to deal with is Deacon versus the Controller of Customs and Excise, reveals an instance of a state official misdirecting himself and misconstruing the facts and the law. It was held that he had failed to properly apply his mind to the matter, and with regard to the statutory provisions in issue, had failed to exercise his discretion at all. It was held that where a government official has in the exercise of discretionary function based his conclusions on incorrect information, or where his actions were wrong in that they were contrary to law or based on factual inaccuracies, his decisions are reviewable and can be set aside by the court. Well, of course, this is now specifically supported by what is set out in Section 6 of the Promotion of Justice Act, PAJA, and that has been clearly legislated. So where there is a mistake of fact of law on the part of SARS, then clearly there would be grounds to have it set aside. And remember, the starting point here was Section 3.1 that says administrative action which materially or adversely affects the rights or legitimate expectations of any person must be procedurally fair. And that is a more justiciable right, one that can be sued upon, that a taxpayer would have in terms of the Promotion of Administrative Justice Act. But we'll come back to more of that in later lectures. That is all on these particular cases in the context of procedurally fair administrative action for now. Until next time, goodbye.